We're going to get started in just a couple minutes, so if everybody can kind of find your seats, that would be great. I guess we'll get started sooner, I guess. Okay. Well, thank you all for coming. Our talk today is co-sponsored by the Alaska Law Review, the Program in Public Law, the Environmental Law Society, the Business Law Society, and DBA. We are so honored to have Professor Jeffrey Fisher with us today. Professor Fisher is an associate professor at Stanford Law School and co-director of its Supreme Court Litigation Clinic. He's argued several cases before the United States Supreme Court, including successfully representing the petitioners in Blakely v. Washington, a case involving federal sentencing guidelines, Crawford v. Washington, a case about the Constitution's Confrontation Clause, and Kennedy v. Louisiana, a case addressing the constitutionality of capital punishment for child rape. Today, Professor Fisher will be talking about Exxon v. Baker, a case that grew out of the May 1989 Exxon Valdez oil spill in Alaska's Prince William Sound. Professor Fisher represents the class of more than 32,000 victims of the spill. He first began working on the case as an attorney for Davis Wright Tremaine in Seattle, and last February argued the case before the United States Supreme Court. He'll be talking today both about the case itself and about the implications of the court's recent opinion for punitive law. So please join me in welcoming Professor Jeffrey Fisher.
Thanks very much. It's a real privilege to be here. One thing that Kelly didn't mention is that I went to Duke undergrad myself. And so it's especially fun to be back on campus and to have been in Cameron Indoor Stadium last night. And Kelly and I were chatting a minute before this, and I think telling you when I was at Duke is a nice way to put in perspective one of the themes of the Exxon Valdez litigation, which is the time it has taken. When the Exxon Valdez oil spill happened in 1989, March of 1989, I was a freshman at Duke. So I was over there on West Campus, actually on East, and obviously had no, I remember when it happened, I had no indication that I would ever have anything to do with the consequences that came out of the spill. Indeed, as the case went to trial, it ultimately resulted in a jury verdict in 1994 in a federal district court in Alaska. At that time, I was a 1L in law school. When the jury trial verdict came back. So again, even though I was in law school, I assure you I had no, no designs on ever being part of the case. But lo and behold, the case has taken a long time, and ultimately I found myself last February, and I'm not sure the date, but it actually might be exactly a year ago today, or it's very close to it. Where we argued the case in the U.S. Supreme Court. In fact, on a day very much like today, a cold, blustery, sunny day, last February in the Supreme Court. So I'm here today to tell you a little bit about what it's been like to work on the case, and then some of the consequences that I see coming out of the case, which I'm talking about in a paper that I'm working on with the Alaska Law Review. So I think I'll talk to you today in 4 steps. First, I'll tell you a little bit about the spill itself. Second, I'll tell you a little bit about the trial and the case as it was put together, because it's, even just on its own terms, a pretty remarkable piece of litigation in American history. Then tell you about the Supreme Court proceedings. And finally, after describing what happened in the court, we'll talk a little bit about what I see as important lessons for the future in light of the case. And I'll try as best I can to leave time at the end for questions or hang around afterwards if anybody wants to talk more. So let me start with the spill. And any story that tells the story of the Exxon Valdez oil spill actually has to start a little bit earlier. It has to start with the discovery of oil in Alaska. In the late 1960s, oil was discovered on the North Slope of Alaska. A very big oil field was discovered. And very quickly it became a pressing issue of national concern how we were going to get that oil to market in the lower 48 states. And there was actually vigorous debate in Congress and in the nation as a whole as to how to get this oil to market. There were two major proposals. One was by land and one was by sea. One proposal was to build a pipeline down through Canada, basically, along the west coast to bring the oil over land all the way to the lower 48. The problem with that was that it would be very expensive for the oil companies to do it that way. So a competing proposal was introduced by which the oil would be transported by pipeline over land in Alaska to the city of Valdez, to the port of Valdez, which is in southeastern Alaska. It has the recognition of being the northernmost ice-free port year-round in the United States. That is how Valdez was picked as the terminus of the Trans-Alaska Pipeline. It is a fjord that cuts into southeastern Alaska where the pipeline ends, and so the deal was that oil companies could transport the oil over land to Valdez and then have oil tankers fill up with the oil and ship down the west coast of the United States to ports in California, Oregon, and Washington. And that's how the oil gets here. That proposal, though, was not without controversy either. And perhaps the biggest concern raised at the time was what would happen if there were an oil spill. What would happen if one of these tankers ran aground and leaked its oil into Prince William Sound, which I think two predominant things need to be said about Prince William Sound. One is it's one of the most stunningly beautiful places in the world and has incredible environmental attributes that are virtually unparalleled. The second thing, and perhaps lesser known across the country, is that it's actually a vibrant commercial center, at least insofar as the commercial fishing industry. The local ports there, and one in particular was at the time the 10th largest commercial port in the United States by virtue of commercial fishing, salmon, herring, and the like, and then the processing activities that went along with it. Along with the commercial fishing, there's actually a population of about 5,000 native Alaskans. So you're talking about indigenous peoples who have lived on centuries off of the land in this area and who have deep cultural roots involved with the bounty from Prince William Sound. So there was great concern raised that what if an oil spill ever happened in this area, because it would be devastating to the regional economy and indeed to the regional way of life. And the oil executives gave, in response, they gave very big assurances that no, we'll be absolutely careful as possible. This will be state-of-the-art operation. An oil spill, while we can't guarantee it will never happen, we'll do everything in our power to be sure that we minimize every last risk to this ever happening. And as the issue went to a vote in Congress, the Congress eventually approved the oversea route by a tie-breaking vote cast by the Vice President of the United States. That's how close it was. But that's the route that was approved, and so in the mid-70s, the Trans-Alaska Pipeline went into operation. So there are four oil companies that collectively run the Trans-Alaska Pipeline and bring that oil to market, and the biggest, of course, is Exxon, which is not just the biggest oil company, but it's the biggest corporation in the world. Exxon ran its shipping operations through a subsidiary called Exxon Shipping Company. And Exxon Shipping Company, unfortunately, was not the careful, meticulous operation that Exxon had promised. In fact, there was something of an alcoholic culture that apparently pervaded the company. And most important for our purposes was the captain of one of its ships that was assigned to this transport route, Joseph Hazelwood. So Hazelwood was an alcoholic. Exxon knew he was an alcoholic. And Exxon did very little about it, basically nothing about it. In 1985, Hazelwood had actually been caught drinking aboard ship, which was a straight violation of company rules. And because he didn't turn himself in, actually under company rules required him to be fired. But Exxon didn't fire him. What they did instead is they let him go into a treatment regime, an AA-type treatment regime, to which he enrolled in a 28-day program and dropped out before it was over. Then when he volunteered to come back to work, his supervisor took him out to a bar, and they had a couple of drinks and decided that Joe was ready to take the helm again. So this is 1986 when Hazelwood gets put back in command of the Valdez. And as a district judge in this case later found, over the next 3 years, high executives in Exxon shipping heard again and again and again that Hazelwood was drinking aboard ship. He was drunk on the voyages. He was holding parties on the vessels. Crews would destroy confiscated liquor by drinking it on board the ship, and the like. So you get the idea. So let's fast forward now to March 23rd of 1989. So that day, the Valdez was set to leave late that evening, I think about 10 p.m. Hazelwood, as was his custom, had spent the day in waterfront bars, drinking. He had somewhere between 5 and 9 double vodkas in the few hours before the ship set sail. That's between 15 and 29 ounces of straight vodka before the ship set off. So late that night, the Valdez set off with Hazelwood in command and his blood alcohol at 0.241 as the ship left port. The trickiest part of sailing one of these vessels, which by the way are about 1,000 feet long, so we're talking more than 3 football fields, is how big one of these ships is. And the amount of oil that it holds is about 55 million gallons of straight crude oil. So these are big things. Set out from port, and the trickiest part is getting out of what's known as the Valdez Narrows and out through Prince William Sound into the open ocean to go southwards. And so during this tricky part of the voyage, Hazelwood is manning the ship from the bridge, and about an hour and a half after leaving port, sees some ice in the shipping lanes. There's established shipping lanes, and sees big chunks of ice floating and calls and gets approval to turn outside the shipping lanes to avoid the ice, which in and of itself was not an unusual move at all. In fact, the tanker in front of the Valdez had done the exact same thing, avoided the ice, moved back into the shipping lanes, and continued down its way. Well, unfortunately, the Valdez, although it successfully moved out of the shipping lanes, never moved back into the shipping lanes. And the ship, once it was turned away from the ice, was headed directly towards an underground reef known as Bly Reef, which is a very well-known reef that had been known and marked for years, as long as the shipping had been going on. But for some reason, with the ship pointed toward the reef, about 2 minutes before it was necessary to make the turn back into the shipping lanes to avoid the reef, Hazelwood went down below. Which, as anyone would tell you that knows anything about maritime work, there's no reason or excuse for that. The captain just went below and abandoned the bridge and left it to the third mate. And the third mate there left to perform 2 jobs: the navigation and the actual work of turning the ship. Was unable to do it. The ship ran right over the reef and ran aground. So in the first of 2 little snippets today to bring this episode to life for you a little bit more, Kelly and I are going to play for you the call once the ship is grounded that Hazelwood makes to the Coast Guard to report the grounding.
Valdez traffic. Yeah, it's Valdez back. We should be on your radar there. We fetched up on the ground north of Goose Island, Boy Reef. And evidently leaking some oil. And we're going to be here for a while. And if you want, so you're notified, over.
Thanks. Yeah. After I played that, the first time I heard that tape, and as I was preparing for the oral argument, I went and I looked up online, it's kind of in a medical dictionary, 0.241 blood alcohol. What exactly does that translate to? And really, what it says is, passed out in an ambulance on the way to the hospital, basically. But because Hazelwood was such an alcoholic, he was conscious. But as you can tell from his voice, we're going to be here a while. I mean, he's not with it. But that tells you something. So, anyways, as happened, they were not just leaking some oil; they were gushing toxic crude oil into Prince William Sound. This, of course, at this point, we're in the middle of the night, just after midnight. By morning, some 11 million gallons of oil had spilled into Prince William Sound and was on its way, spreading very quickly. There was actually a day or two of relatively calm weather by which they might have contained the spill to some degree. But unfortunately, they simply didn't have the cleanup equipment to deal with the spill. It just didn't exist in that part of Alaska. And this was something everybody knew. And this was part of the deal going in, and I didn't mention with Congress, but one of the concerns was not just a spill could happen, but it would be so difficult to contain the spill. Everybody knew this. Exxon knew this. The governmental authorities knew this, but lo and behold, Exxon hadn't been careful, and it had happened, and now we didn't have any way to deal with it. So a couple days passed. By the time we were finally able to mobilize equipment into the area, a storm had kicked up, and the oil had spread far and wide, ultimately coating 600 miles of coastline in Alaska. And just to translate for you, if you went straight east from here, roughly, to Cape Lookout, North Carolina, and coated 600 miles of beach, you'd end up in Cape Cod. So that's how much land we're talking about. I think some people don't understand how big the spill was because it's all within one state. But Alaska is just so big that it doesn't give us the proper scale to understand how much we're talking about here. So the oil got into the water. As a result, the fishing season was closed all through southeastern Alaska. Subsistence living went to an immediate halt, and basically the local economy was wrecked. Many of you probably have seen pictures of the cleanup effort as it progressed on TV. It became a very public event. Exxon spent roughly $2.1 billion by the time it was done over a few years trying to clean up the oil, or at least trying to make it look like it was trying to clean up the oil. A lot of environmentalists will tell you that if some of you have seen those pictures on TV of the guys in the bright yellow suits holding hoses and spraying the beaches, that was actually doing more harm than good. It was just driving the oil deeper into the ground. It was killing all the organisms that lived on the beaches and the like. But that's what they did. And in fact, part of the evidence at trial was actually radio tapes of the cleanup effort as it progressed, with Exxon individuals talking to local governmental individuals. And one of the things that was said actually the morning after the spill, as they were mobilizing people, one Exxon executive says on tape, he goes, I don't care if they're picking up 1 gallon of oil a day. Get people out there with bright yellow uniforms so people can see them. And so, in some level, that's what was going on. So, shortly after the spill, and as the cleanup was taking place, litigation commenced. There were lawsuits filed all across Alaska from all kinds of affected individuals. There were, as you can imagine, hundreds of lawsuits filed in state and federal court for various kinds of damage to the commercial fishing industry, to Native Alaskans, to municipalities who had to divert all of their city resources to addressing the spill, and right on down the line. Ultimately, those cases resulted in about $500 million of compensatory damages or settlements that Exxon paid out. So things like the amount of fish that fishermen would have caught that year translated into dollars, some damages for the subsistence living, some damages toward municipalities, et cetera. About $500 million all told Exxon paid in compensatory damages. There was also a separate environmental case that happened. Those were governmental actions brought by first the U.S. government and the state of Alaska sued Exxon. Brought federal cases against Exxon under the Clean Water Act and similar environmental laws for recklessly spilling oil and the like. Exxon ultimately pleaded guilty to 3 federal crimes and certain state civil fines, and paid another $1 billion in restitution and governmental settlements. And there was one moment, so that they actually Exxon settled with the federal government about a year into the case, if even that. And the plea hearing, so anytime you enter a guilty plea, you have a hearing before the district judge, and the district judge says, well, why is this a good deal? And basically asks both sides that question. And there's it's an interesting transcript to read, because he asked the U.S. attorney, what's the government's interest in settling this case with Exxon for this kind of a plea deal? And the U.S. attorney says an interesting thing. He says, well, we think we could prove a lot more and get a lot more out of Exxon. But the problem is, there's 2 problems. One is the oil is in the water and is causing more harm every day. So we just need the money now. We need some money now. We need something to do. We need something to start addressing this problem. Because if we get twice this much in 10 years, it doesn't do us any good. We need whatever we can get right now. So in that position, Exxon was in a pretty strong bargaining position, you might say. The other thing the U.S. attorney told the district judge, we said, I just don't know that we can fight Exxon to the degree that it's going to be necessary to fight Exxon to do better. There's one other oil spill that happened in France, a very serious oil spill that was still in, the U.S. attorney told the district judge, and 15 years later it's still in litigation. And us knowing how Exxon is, we could be here 15 years later and still not with a solution. And so we think, just again, in the interest of time, we have to get something now. So those of us who ultimately worked on the civil punitive damages case sometimes look back and say, well, when the federal government goes into court and says, we just don't have an interest to fight these people, that might have told us something about what we were in for by continuing forward in this case. But nonetheless, we did. And that's because there was a separate part of the case that was piggybacked on to all of these compensatory claims, and that was the claim for punitive damages. And I think most of you, I'm sure, are familiar with punitive damages, but the basic idea is that in a tort suit, you can get not just compensatory damages, but punitive damages, which is extra money for punishment and deterrence and the like, when the defendant's conduct is so egregious, reckless, malicious, that it deserves this kind of extra surcharge. And plaintiffs all asserted punitive damages claims. Ultimately, they were all consolidated into one single claim. So in federal district court in Alaska, the district judge certified a class of some 32,000 fishermen, Native Alaskans, seafood processors, and the like. And the class consists basically of everyone who had or could ever have a punitive damage claim against Exxon for the fallout of the Exxon Valdez oil spill. Certified into a class, ultimately brought to trial because, in contrast to the civil claims for compensatory damages and in contrast to the environmental claims, Exxon, from the minute these claims were filed, took the position that no settlement was possible on punitive damage claims. Just as a straight company policy decision, there was going to be no discussion of settlement of these claims. And you might say there's different reasons why Exxon took that position. One might be that they just simply felt they were illegitimate, that this had been on some level an accident. Exxon, of course, as they told us many times in the case, they hadn't purposefully dumped the oil into Prince William Sound. They hadn't done it on purpose. They were sorry it happened. They hadn't tried to gain by doing it. They hadn't tried to swindle, as some companies do, fraudulently swindle people out of anything. It was an accident, and they didn't feel like they should have to pay punitive damages. Also, and this goes back to my joke about the U.S. attorneys, also, I think Exxon had a very strong institutional interest in making damn sure that if something like this ever happened again, that nobody'd be stupid enough to go after punitive damages against them. They want to make this as painful as possible for the plaintiff's lawyers who wanted to come after them in this case, and so that people wouldn't do it again, or at least they'd roll over in a future case. So there was going to be no settlement in the civil case. The case ultimately, as I mentioned earlier, was tried in 1994 in a federal district court in Anchorage, Alaska. Actually, before a district judge named Russ Holland, who himself had been an oil company lawyer before he was put on the bench by Ronald Reagan in 1986. And actually, and as I said earlier, I was walking around campus here when this was all happening. But as I understand it, Judge Holland, as you might expect, was quite hostile towards the plaintiffs when the case started. He, perhaps because of his experience with the oil companies or whatever, but he was quite hostile to the litigation and didn't give the plaintiffs a break at all as the case progressed ultimately towards trial in 1994. The trial occurred over 83 days. There were over 1,000 depositions taken. Over 100 witnesses took the stand in the trial. The trial was actually tried over 4 separate phases, and the trial itself was really a minor miracle and has been praised from all sides as just a matter of judicial craftsmanship and oversight. To get this thing actually tried within 5 years. And he did it, and he did it well. The case got tried. In September of 1994, the jury returned a verdict of $5 billion in punitive damages. $5 billion at the time was 1 year's profit for Exxon. And I think that's how the jury picked the number they did. As you might know, if you looked at the financial pages these days, $5 billion these days is about 5 weeks' profit for Exxon. But at the time, it was 1 year's profit. So that's what the jury decided that Exxon should pay in punitive damages for its role in causing the spill. Upon getting that jury verdict, Exxon commenced two efforts. The first was obviously an effort of appeals. It set out to appeal this as much as up to the Supreme Court if that's what they had to do. The second thing they started doing was much more unusual. Exxon actually sought out to do something I'm not sure has ever been quite so explicitly done, which is they set out to start financing academic scholarship to undercut the verdict. In other words, they started seeding academic literature and law reviews with articles that they hoped would later be useful in persuading the Supreme Court to invalidate this decision. And if you think that sounds conspiratorial, there's actually an article from one of the professors that Exxon approached who ultimately he turned them down after ultimately Exxon withdrew their funding from him because he was writing something they didn't like. And he wrote an article about his experience working with Exxon when they were paying him to write pieces to undercut the verdict. But several other academics did accept Exxon money and write very influential law review articles in the late 1990s. Among them, Cass Sunstein at University of Chicago, Steve Chevelle at Harvard, and several other professors accepted funding from Exxon and wrote highly critical articles of punitive damages in the late 1990s. Meanwhile, this case is working its way up the appellate system. And meanwhile, the U.S. Supreme Court is starting to decide cases involving punitive damages. Ultimately, after winding our way through the appeals system, the Ninth Circuit upheld our right to get punitive damages, but cut the size from $5 billion to $2.5 billion. The $5 billion judgment bore, you might say, a 10-to-1 ratio to the compensatory damages of $500 million. The Ninth Circuit said that under the evolving U.S. Supreme Court jurisprudence, which I'll say a word more about in a minute, that 10-to-1 ratio was too high, and that something like a 5-to-1 ratio was more appropriate. So the Ninth Circuit cut the judgment to $2.5 billion. And then Exxon sought review in the Supreme Court. And in the fall of 2007, the Supreme Court accepted review of the case on two questions. The first was whether or not the plaintiffs were entitled to punitive damages at all as a matter of maritime law in a tort like this. And the second question was whether or not, if we were entitled to punitive damages, whether that $2.5 billion figure was too high and whether the court ought to reduce it. So at this point is where my involvement in the case really increased. I'd been involved in some of the latter appeals in the Ninth Circuit. In the U.S. Supreme Court, I in some ways took the lead and ultimately was the one who did the oral argument in the case. And I think there were three real challenges as we went to the U.S. Supreme Court in this case that I'll say a word about, because they're not just challenges to this case. I think some of them speak larger to other challenges that you might think of in other cases or might experience yourself. The first one was just a challenge in this U.S. Supreme Court when you are on the other side of a big corporation. This U.S. Supreme Court is a very, very solicitous court, perhaps the most solicitous court ever toward big business. And that's something that many people have written about. I'm sure it's not news to you. Jeff Rosen wrote a fairly good piece about it in the New York Times Magazine maybe about a year ago. And there have been plenty of other pieces written about it. In particular, the U.S. Chamber of Commerce over the past decade or two has undertaken a very, very sustained and careful effort to not just to get the court to be more solicitous toward business concerns in general, but also more solicitous towards business concerns, in particular with punitive damages. The Chamber of Commerce says that punitive damages is their number one concern, or at least that's what they said until recently, when it comes to litigating cases. And it's not hard to see why. That's where they have the biggest financial exposure, and as businesses will tell you, it is not just where we have the biggest financial exposure, it's where the risk is the most difficult to predict. It's very difficult oftentimes for businesses to know whether they're going to get hit with a huge verdict or a small one or none at all. And this is a cause of great concern. So finally, in the mid-'90s and into the new millennium, the business groups were successful in getting the court to step in and decide, for the first time in U.S. history, that the federal Constitution imposes limits on the size of punitive damage awards. And you may have studied these cases in class, first in a case called BMW against Gore, then in a case called State Farm versus Campbell, being the two big cases. More recently, in a case where Philip Morris Tobacco Company brought a case up to the Supreme Court. The court has a few times in recent history taken very, very big punitive damage awards with triple-digit ratios, not 10-to-1 or 5-to-1, but triple-digit ratios. In BMW, it was 500-to-1. In State Farm, it was 145-to-1. The Supreme Court has said the Due Process Clause has to set some sort of limits on huge punitive damage awards. And so that was the background law going into the case. And in fact, big business is so keyed into the Supreme Court that I think that the two most recent appointees of what I've read and heard, second perhaps to only executive power, when it came to the Bush administration's vetting as to what the most important qualities in their new justices would be. It was concern for big business. So John Roberts, of course, until being put on the D.C. Circuit, was a lawyer for Hogan and Hartson, who worked very closely with the Chamber of Commerce and was one of the cadre of DC-based Supreme Court lawyers advocating business concerns in the Supreme Court. Sam Alito, although he'd been on the bench for many years in the Third Circuit, was known to share some of these same views. And so it was very important to the business community that the Bush administration pick people like this. They, in fact, did. And in fact, it was a matter of a little bit of irony that Sam Alito was actually so favorable that he happened to own about $300,000 worth of Exxon stock. And so he had to recuse himself from the case. So they actually did too well when it came to Sam Alito. And so he had to recuse himself from the case, thereby creating an 8-justice court that we were going to argue the case in front of. And even though Exxon, as it went up to the court and it was covered in the media to some degree as being a maritime law case, it really very quickly became clear that it wasn't a maritime law case. In fact, 3 minutes into argument, and Exxon was the first to argue because they were petitioning in the court, and Walter Dellinger, who taught at this great law school for so many years and I think still retains an affiliation, Walter was representing Exxon, and about 3 or 4 minutes into argument, the argument started out on the question of whether we could get punitive damages at all. And that question turned largely on whether or not Exxon could be held liable for the recklessness of the captain of Hazelwood as its agent, or whether or not Exxon could be held liable only if there was proven to be recklessness and complicity much, much higher up in the company. And even though much of the plaintiff's proof at trial had even been in the latter, as I described it to you with this knowledge over the 3 years, a jury instruction following Ninth Circuit law had told the jury it was enough to get into the door of punitive damages to find that Hazelwood was reckless, which of course was a laydown. Everybody knew that much. And so Exxon really had 2 choices in making this argument. One was to make it in a maritime way, to say whatever the rules are generally with companies being held liable for their agents, and even agents with some degree of responsibility. Ship owners can't be held liable for captains because captains, and this is a historical argument that actually has some historical grounding in maritime law, because captains, once they set sail, are out on the high seas so far away from company control that you can't fairly attribute their actions to the company. And in fact, it would be harmful if you did, because the captain, when he's at high seas, needs to be able to make split-section decisions for safety, et cetera, to protect the crew. And it would be bad policy to do that. Another argument that Exxon could make would just be to make the straight-up argument that forget maritime law. You just have to restrict punitive damages to wrongdoing that is at such a high level in the company, like the president or vice president or policy-making individuals, that Hazelwood didn't go high enough. And 3 minutes into argument, Exxon had managed to sort of not really pick one of these 2 arguments throughout its briefing. 3 minutes into the argument, Walter was pressed directly. What exactly are you arguing? And right there, he just threw the maritime part of the case overboard, so to speak, and just said, no, you have to be a policy-making individual in a company to expose the company to punitive damages. So 3 minutes into the argument, this was no longer a maritime case. It was just a straight-up business law case in the Supreme Court. And what was interesting about Walter's decision, as I said, the maritime argument actually had some historical groundings. Now, we argued whatever those reasons were back in the day, they don't hold force anymore because you're in constant contact with shore on satellite and radio and the like. But he didn't make that argument. He made the business argument, which is a matter of tort law. Walter was swimming against the law, and it depends how you count, but 47 or 48 states had a law of punitive damages in their tort law, that, like the one we were arguing, that said that someone like Hazelwood was easily high enough in the company. But Walter took the very aggressive view, Exxon took the very aggressive view, that the Supreme Court should, as a matter of federal common law, deviate from the overwhelming rule in the states. Ultimately, the four justices agreed with Walter on that. And probably only because Justice Alito was recused did we actually win that issue. We split 4-4 on the issue, and the rule in the Supreme Court is a tie goes to the person who won below. So that's how that ended up being handled. But that tells you, again, something about how business-friendly this U.S. Supreme Court is. The second challenge arguing in the court was just arguing about something that happened so long ago. Punitive damages really, in their essence, are about outrage. They're an expression of outrage and societal need to punish and deter. Well, it's really difficult to argue about that when you're arguing about something something that occurred 19 years ago, and even the jury verdict happened 14 years ago, and it happened 4,000 miles away. And I thought this was one of our biggest challenges in arguing the case to the court, was just to try to bring it back to life. And I played that tape for you here. That's something I couldn't do in the court. You don't say, hold out an oral argument. Give me a minute here and let me just play this for you. Likewise, there are various documentaries that were done about the oil spill. And one of them, Kelly and I had talked about playing today. I think in the interest of time, we'll skip it and just say that she can post it or let you know where it is, because there's a couple of very well done documentaries that describe the effect of this on the fishermen and on the community and the like. And to me, at least, and I'm in some ways like you, I wasn't there when it happened, it brings it to life in such a vivid way. Again, you can't do that in the Supreme Court. So we had to try to bring this thing back to life many years later. There was actually an op-ed in the Anchorage Daily News a few days before trial. A few days before the U.S. Supreme Court argument that made this point, I thought, very well, and said, as I said to you earlier, would this case come out the same way if you could still go out on Cape Cod or in the East River or in Chesapeake Bay and pick up rocks and smell petroleum, which is what you can still do in Prince William Sound, Alaska? Would the justices have the same visceral reaction to Exxon's arguments and to our arguments in the case if it was visiting them on a daily basis the way it still does Alaska's? And the thing that's funny is that while outrage, as I put it in one of the papers I filed, outrage dissipates naturally in society, and that's what was big of a challenge for us. Outrage, generally speaking, has not dissipated in Alaska, at least hadn't at that time. The time that took to litigate this case, as anything, hardened the resolve and made some of the local residents even more committed to the cause than they were when it started. And the final challenge in the Supreme Court was the fact that there was one way that did matter. This was a maritime case, and that was, instead of invoking the Constitution to make the punitive damage verdict smaller, Exxon could argue that the court could invoke federal common law, which after all is what maritime law is. It's federal common law, to reduce the size of the verdict, which is to say the court could act more explicitly on its own policy judgments and policy views than it can under the Constitution. And we could talk legal realism in this room about whether or not it's doing that anyway under the Constitution, but maritime law arguably gave the court a license to be at least more upfront about it, if not to just have more power outright. And this did two things. One is it brought Justices Scalia and Thomas into the case, who up until the Exxon case had said they weren't going to participate in this punitive damage jurisprudence because the Due Process Clause doesn't say anything more about punitive damages than it does about abortion. In their view, substantive due process across the board is illegitimate, and they weren't going to play that game. But because it was maritime law, they were able to step in and, in a sense, decide the case. Even more broadly, it put me at a real disadvantage and our side at a real disadvantage in this Supreme Court. And say what you like about this Supreme Court, but there's one thing, it's divided in many ways, but there's one thing that they're not divided over, and that is about their confidence in themselves as an institution. This is a court that has no trouble deciding the most difficult policy questions that face the country, and in feeling like they can do it through the judicial process without batting an eye. And so one of the things Exxon was arguing was, look, Supreme Court, you need to establish some hard and fast limits on punitive damages. And indeed, look, there's about 20 states that have done so. And it's true, there are about 20 states that have caps on punitive damages of one kind or another, either a ratio no more than 2 to 1 or 3 to 1, or a dollar figure no more than X amount of dollars per plaintiff. And that's true, but our response to that was, yeah, about 20 states have done it. Every one of it has done it through legislative action. There has never been a court sitting in common law, whether it's a federal court or a state court, that has basically legislated from the bench, and forgive this silly phrase, but written policy law type judgment in this kind of a context. And so we said, really, you shouldn't do it. And we did a lot of research. I had a memo prepared for me right leading up to oral argument that I called the "You Can't Just Make It Up" memo. And we had I had everything from Justice Brandeis back at the turn of the century saying the common law moves in molar, not molecular motions. In other words, it should be one case at a time. I had stuff from Robert Bork on the other side of the spectrum talking about the common law in the age of statutes and how nowadays courts should be even more reticent to invoke the common law toward policy ends. But nonetheless, I found myself at oral argument really swimming upstream when it came to the U.S. Supreme Court, basically telling them you don't have the authority to enunciate a broad policy. I mean, the Bush administration had tried this in Guantanamo, right? You don't get very far there. Think of all the other examples of telling the Supreme Court, you should keep your hands off of this. You don't get very far. And there was a moment in argument where Justice Souter put it to me very, very pointedly and said, we've looked around and yeah, I hear you about Justice Brandeis, but we know something now that he didn't know. And that's that punitive damages are a real problem and that they're unpredictable. And shouldn't we just establish a number, a hard and fast number? And it was one of those moments in argument. There are some times where you walk away and only later do you realize, well, that was an important moment. Or sometimes you read the decision and only then do you realize the import of a moment in argument. Well, that was a moment in argument that even as it was asked to me, I knew was very, very important. Because not only was our strategy was basically to keep the four moderate liberals, to keep Souter, Breyer, Ginsburg, Stevens. And here we had Souter, one of the four I needed, asking me this question and asking it to me very pointedly. And I gave him my best answer with Bork and Brandeis and the like. But as it turned out, it wasn't enough. And the court ultimately voted 5-3 with Souter joining the four more conservative justices to as I said, we are allowed to have punitive damages, but they cut the size of the award from $2.5 billion to $500 million. The Supreme Court, in other words, cut the ratio from 5-1 to 1-1. Now, 1-1, mind you, is a ratio that is lower than even almost all the states that have stepped in legislatively to enact ratios governing punitive damages. But the court felt confident enough to step in and do this, and to do this in a very, very aggressive way, that we lost the case. We lost the case in part, I guess, by that much. And another way to look at this, and this goes back to the second challenge I had in the court of litigating something that happened so long ago, Justice Breyer actually writes a concurrence, a dissent. And in Justice Breyer's dissent, he says, well, I agree with the majority that punitive damages are a terrible thing and they've run amok and we should have strict limits on it. But in my view, the facts of this case are so egregious that the district judge, who, as I mentioned before, started out the case very, very hostile to the plaintiffs, completely did a 180 upon presiding over this trial. And so once he saw the evidence and the testimony in this trial, actually, Exxon would be the first to tell you was extraordinarily hostile towards Exxon once the trial had taken place. Justice Breyer said, boy, with this kind of a record and with this kind of a careful trial judge who felt so strongly, I'm going to defer to this trial judge that this is an extraordinary case that requires a higher than ordinary ratio. And that's another way that when I stay up at night, I think, well, boy, I lost this case on the facts on some level. On a cold record, 14 years later, I lost by 1 vote. And so that definitely hurts sometimes. So let me say a few things about the case looking forward, and this speaks a little bit to the piece that I'm writing for the Alaska Law Review. So in many ways, at least the public perception and even the perception within the academy and the bar of the punitive damages jurisprudence in the court is an extraordinarily favorable big business court is just substantively reducing the size of punitive damage awards. It's invoking the Constitution or maritime law or whatever it wants to just, as a policy matter, say punitive damages awards have to be small. As it happens, and I think you could think that Exxon is in a sense proves the point that we went into this case, unlike the previous few cases that the court had sliced triple-digit ratios down to size. Here we had a 5-to-1 ratio. We had a case that, unlike these other cases that the court had reduced, we had a case in which the compensatory damages weren't sort of soft, fluffy, emotional harm and distress damages. They were hard economic damages. And even that the court felt didn't give us an entitlement, or at least open the door to extra compensation in the way of the punitive award. In contrast to the other cases, we had rigorously detailed jury instructions to guide the jury in making its determination as to what the proper number should be. Nonetheless, the court cuts down the size of the award to a 1-to-1 ratio. So it looks from the outside like the court is just taking this strong, substantive, muscular view to cut the size of punitive damage awards. But what I argue in the piece, and actually what I believe, is that that's too easy of an explanation, and that's really not right. And even though the court's result was fairly dramatic in Exxon, I think that the problem that the court perceives is less substantive and much more procedural in nature. And this is where the work that I've done in criminal sentencing comes in. If you've studied criminal sentencing and punishment, you know that the Supreme Court, certainly in non-capital cases, the Supreme Court basically says legislatures can prescribe any punishment they want. I come from a state in California where you can put somebody away for life in prison for a third offense of stealing a slice of pizza. And the U.S. Supreme Court says that's fine under the 8th Amendment Cruel and Unusual Punishment Clause. We're not going to tread on legislative authority to decide the policy question of what the proper punishment is. And in capital punishment, they've done much the same thing, and I'll say another word about that in a moment. But I think but contrast that with punitive damages. In punitive damages, there's virtually no legislative enactments or involvements at all. It's all a matter of common law. And what the U.S. Supreme Court said in Exxon, and I think the most telling line of the opinion, is the problem with punitive damage awards is the stark unpredictability of them. And the court has decided, rightly or wrongly, and there's an empirical debate about this I'll set aside, but the Supreme Court has decided that the punitive damage awards are just too unpredictable, that a defendant doesn't know when they're going to get hit, or much more important, how much they're going to get hit with. And that this is intolerable under basic rule of law principles. The Holmes bad man should know what he's exposing himself to, whether it's a criminal case or a civil case, if he acts wrongly. And the Supreme Court has just finally said, enough's enough. If legislatures aren't going to step in and regulate punitive damages, we're going to do it for them. And so I think what you'll see is that the court actually is viewing, a lot of people have written pieces, and I think Erwin Chemerinsky, when he was at Duke, wrote a piece criticizing the court and saying it's so unfair that they have this robust substantive protection for corporations of punishment and virtually no protection for criminal defendants when they get punished in criminal cases. And it's so unfair and it doesn't make any sense. But actually I think what the court is saying is that they see punitive damages as they currently exist much like a couple of federal sentencing realms that they actually did do something about. One is the federal sentencing system as it existed before the federal sentencing guidelines, where wide open ranges existed and defendants could get any punishment from like 0 to 40 years in a typical case, and they had no idea what they were going to get. The court sent some signals it was displeased with that in Congress before the Supreme Court ultimately put the hammer down. Congress stepped in and enacted the federal sentencing guidelines, and so now we have a rigid system of guidance given to juries and judges in federal criminal cases. And the other area that bears a distinct likeness to punitive damages right now is capital punishment law as it existed prior to 1972, when the U.S. Supreme Court decided in Furman against Georgia that all state death penalty systems violated the 8th Amendment. And remember, the reason why the court said they violated the 8th Amendment was not because the death penalty is in and of itself disproportionate punishment. They said the death penalty is too unpredictable. As Justice Stewart said at the time, it's like being struck by lightning. There's no good way to know when a jury is going to pick which defendant gets sentenced to death in a capital case. And as a result of Furman, legislatures got involved, they stepped in, they now have rigid, detailed systems for deciding who gets capital punishment and who doesn't, involving juries that have to find aggravating factors and weigh them against mitigating factors and the like, and various kinds of review. And so again, you have legislatures that have stepped in, and now the court generally keeps its hands off. And I think that's what the court says needs to happen when it comes to punitive damages. The court. So if you're a person who's sitting in this room saying, I don't want something like this to happen in the Exxon case again, or just more generally, I think that punitive damages are a legitimate a legitimate tool in the legal system that ought not be curtailed. The solution, I think, is not to continue to rail against the Supreme Court. I don't think that's going to get anybody anywhere. The solution is to go to legislatures and to fight this on a policy level and get legislatures to step in and say, here's when punitive damages are allowed, here's how much can be awarded when there's this kind of conduct, here's how much can be awarded when there's that kind of conduct. Once the legislature steps in and does that kind of thing, I have a strong suspicion the court is going to keep its hands off. And I'll say one final word and try and leave a minute for questions. You might be thinking, Kelly introduced me at the beginning and said that I handled last term another case involving punishment, the Kennedy against Louisiana case. And that was the case where I argued, and ultimately successfully, that the Eighth Amendment prohibits the death penalty for the crime of child rape. And you might say, and the court wrote an opinion that said not just for child rape, but any non-homicide offense cannot be subjected to the death penalty. And you might say to yourself, well, that seems inconsistent with what you just told me. It sounds like there the court stepped in at a substantive level and said this crime isn't serious enough for this punishment. And while a couple of the justices might have thought that, the more I've reflected on Kennedy and the strands of strategy I had going in and reading the opinion as to what really worked at the backside, I don't think the court, at least Justice Kennedy, who wrote the opinion, I don't think he decided in his mind that no crime of child rape could be so serious that it could warrant the death penalty. I don't think he thinks that. I think what he decided was that there would actually be no way as a legislative matter to regulate this punishment in a way that made it non-arbitrary. Because the difficulty, and this is something that we put in our amicus briefs and talked a lot about, even in argument in the court, is that once you expand the death penalty beyond a narrow slice of murderers into non-homicide crimes and even just the non-homicide crime of child rape, you open the door to tenfold more cases, at least, where the death penalty is going to be on the table. At the same time, it's at least the case that juries are generally not going to see this crime as serious as murder. And so you're going to have, just by definition, an incredible problem with arbitrariness when it comes to imposing the death penalty in those kinds of cases. And that's ultimately what I think drove Justice Kennedy to write the opinion that he did and said, this is the rare case where even a legislature is not going to be able to sufficiently regularize this kind of punishment. But, as I said, I don't see any reason why punitive damages have to be that way, and they can be treated just like more ordinary criminal sentencing. And so I think that's where, if a legislature steps in, we can kind of restore the balance in this line of jurisprudence. So I'll stop now and answer a couple questions if you have them. Yeah.
So is the court laying down a firm line that punitive damages must be a 1-to-1 ratio, or is there still any scope for going into returns to be slightly higher?
Now the question is whether the solid rule now is that juries are limited to a 1-to-1 ratio. As you might expect, there's a good deal of debate about that. The business community has come out after Exxon and said, aha, now we have a solid 1-to-1 rule that juries can't go above, at least in cases involving lots of money and big damages. I think that most courts have rejected that argument on a couple of different bases. One is, after all, as I mentioned, Exxon rested on federal common law. It did not invoke the Constitution, so there is still this issue whether the Supreme Court has to give more deference to states when it comes to regulating punitive damage judgments with the Due Process Clause instead of as a matter of federal common law. And there's good reason to think that they will give that kind of deference. In fact, if Exxon itself had been a state case, this is another thing that I can stay awake at night about. This had been a state case, I would have won, because Thomas and Scalia would have been my fourth and fifth votes if this was just a matter of constitutional law. So if you view it that way, that's another way to say I think this one-to-one thing is still up in the air.
How influential the the Exxon funded studies and law review articles you think were? Because I think after that there's a lot that came out that pretty much picked those studies apart and mentioned that they were Exxon funded.
Right.
And so I'm wondering how much deference the Supreme Court gave to those versus the rebuttal reviews. And
I'm glad you asked that because it's something I meant to speak a word to. So the question is how much the studies that Exxon funded played a role in this. Unfortunately, a lot. And let me tell you why. So first, I should give a shout out, as they say these days, to Professor Vidmar on the faculty here, who was one of the leading academics who critiqued the Exxon-funded studies. And he's written some really terrific pieces on that. So there's two funny things that happened in the Supreme Court with respect to the studies. One is the Supreme Court dropped a footnote, and it's footnote 17 in the opinion, that says, when it's talking about unpredictability and punitive damages, it says, we realize there's a body of scholarship that actually speaks to this. But because Exxon funded it, we declined to rely on it. And this is a really fascinating footnote and one that has sent, I wouldn't say shock waves, but waves through the academy, and people are talking about this a lot. So the court told us it declined to rely on these articles. Now, if you look at the opinion, what you'll find is that as it happens, the reasoning in the opinion does not track Exxon's brief. Exxon made lots of substantive arguments as to why this verdict was illegitimate. We rebutted all those arguments as best as we could, and the court doesn't rest on any of those grounds. You know what the court's opinion looks like? It looks like Cass Sunstein's article in the Yale Law Journal. That's what it sounds like. And in fact, the court, even though it said it declined to rely on these studies, in the previous case involving punitive damages in the Supreme Court called Cooper Industries, the court had cited Cass's work 3 times. So the court is very familiar with this work, and one will never know, but I think was probably more influenced by it than what Exxon wrote in its own brief.
You mentioned that, like, in the late 90s and stuff, there's this general feeling partly from Exxon that's, like, against punitive damages and have, like, a sort of outrage against them. Do you think that's changed in legal academia since? The general feeling towards punitive damages?
In legal academia, I guess I would say it's been balanced. It's been more balanced all along. I think you'll find plenty of academics that have difficulties with punitive damages, whether they be kind of in the Cass Sunstein realm of these are too unpredictable and not sufficiently regulated, whether you or see them just straight out. There are a lot of law and economics types that think that they're economically insufficient and wasteful. And then you have plenty of people on the other side too. So the academy is actually fairly balanced. The problem is that the bar is not balanced, at least when it comes to the U.S. Supreme Court bar, because many of you may know from doing summer job searches, or especially if you're interested in appellate law, that Supreme Court practices and appellate practices are concentrated in Washington, D.C. at Hogan & Hartson, John Roberts' old firm, and about a dozen other firms, O'Melveny & Myers, where Walter works, and the like. All of these firms have a solid base of business clients. Almost all of the top repeat player private lawyers in the Supreme Court are on one side of this issue. And in fact, when the court granted cert in this case, we had to go out and try to find people to help write amicus briefs for the various parties that wanted to weigh in on our side. I couldn't find a Supreme Court lawyer in any major Supreme Court practice that was willing to come in on our side of the case. Because positionally they said, I will not come in favor of punitive damage award because it would be too damaging to my business clients and my relationship with them. So as a matter of the bar, it's very imbalanced. As a matter of the academy, it's much more balanced. One more?
You mentioned that you thought that there was a problem because the Supreme Court possibly didn't connect with this case in the same way, being with the distance. Do you think you were aided by that in the Ninth Circuit, considering many of those justices probably were closer in terms of geography and probably had friends that were probably affected? Or do you think they were straight applying the BMW State Farm standard as it applied to maritime law?
So the Ninth Circuit panel that we had did include one Alaska judge, Andy Kleinfeld, and so he obviously was closer to the events than others. The other two judges we had were Mary Schroeder from Phoenix, and actually, as it happens, we started out with we've actually now in our third judge for the final seat in the panel. We've one judge died. And then Judge Browning in San Francisco sat on the appeal that ultimately went to the Supreme Court. Now he's been replaced by Judge Thomas in Billings, Montana. So just like so many other parts of the case, it's taken a toll on the judiciary. I don't know that they felt, I mean, certainly Judge Kleinfeld brought a local flavor to the case, although he himself is a fairly idiosyncratic judge. I don't know that we were hurt or helped in either direction by the other two judges and their familiarity. I don't think they had much more or less familiarity than anybody else on the U.S. Supreme Court when it came to deciding the case. They might know Judge Holland a little bit more, so maybe they were a little more inclined to defer to Judge Holland. But again, I don't think there was a big difference between the Ninth Circuit and the U.S. Supreme Court. I think the biggest difference was just different people deciding the case.
If you say that the Supreme Court's holding is that they want more clarity for the use of punitive damages, have we seen empirical evidence on the backside of state legislatures or Congress creating more detailed schemes for punitive damages?
So not yet. I have not seen, and this is part of why I want to write this piece, is to kind of get people to at least bring another idea into the conversation. Because what has been happening, particularly in the academy and in plaintiffs' lawyer circles, has been just sort of railing against this whole idea of substantive due process, and it's illegitimate and it's unfair and the like, rather than trying to find a solution to the problem. So there's been very little in the way of legislative enactments. In fact, to the extent there's been legislative action over the past 5 years or so, it's been more in the other direction. Chamber of Commerce and local Chamber of Commerce getting caps of very kind, thinking of it as in a tort reform sense. But if you want some empirical evidence for what I'm saying, I think I can still give you some. And here's one place that is that the Supreme Court has still never invalidated a punitive damage award or any other kind of civil punishment that does come out of a legislative enactment. Think about antitrust. In every single antitrust case, you have a 2-to-1 ratio because it's treble damages. That's basically a doubling of the compensatory damages for punitive or quasi-punitive reasons. And they're huge judgments. You can have $1 billion at stake in an antitrust case. The Supreme Court has never suggested that it's willing to invalidate federal antitrust law, RICO, various environmental statutes, the patent laws. There's all kinds of treble damages and punitive damages laws that exist and have pre-existed this line of jurisprudence that allow for treble damages, 3-to-1 ratios, and the like. The court has just never even glanced at these things. But if you believe what the Chamber of Commerce tells you, that every business case that involves big money is limited to a 1-to-1 cap, all of those laws would be unconstitutional. Every one of them. And I don't see any interest in the court to going there, and so there has to be a reason, and I'm trying to give you what I think is one reason. Well, thanks a lot. It's really been fun to be here, and I'll hang around for a minute if anybody else has any other questions.